Hello, everybody down in North Carolina or wherever you may be watching this. I'm Frank Bowman, and before commencing my remarks, I wanted to extend my thanks to Professor Hessick and for all the folks who've worked so hard to put together a great gathering under challenging circumstances. But with no further ado, let me then proceed to my remarks. Apprendi versus New Jersey and its sadly inevitable offspring, Blakely versus Washington and United States versus Booker, are in the case book as landmark decisions about the reach of the Sixth Amendment right to trial by jury. In truth, of course, none of these decisions have anything more than a formal relationship to what juries can or should do. In all the years that I and the rest of us on this panel have spent wrangling over the Apprendi line, and we've spent the last 15 years doing that, none of us have ever really given a tinker's damn about what happens in the jury room. We don't really talk about it. We rarely, if ever, research it. It just doesn't matter. These cases were about judicial power, period. From the outset, they were always about the federal judiciary's revolt against what judges felt to be an intrusion by Congress and its chosen instrument, a sentencing commission, into an area that judges believed to be peculiarly their province. The Sixth Amendment jury right was just a convenient hook on which to hang a project of judicial self-aggrandizement, or perhaps just self-defense. That said, it's worth asking what it was about the Federal Sentencing Commission and its guidelines that so grated on federal judges that their most senior panel, our Supreme Court, would be moved to invent constitutional doctrine to neuter it, and in the process impose significant restraints on state sentencing law. Because federal sentencing has always been my focus, I think it's also worth asking what kind of federal system we're left with 15 years on. After Booker and 20 years after Apprendi, and what, if any, prospects there are to improve it. Today, I advance three propositions. First, although in my view, the Apprendi line is a constitutional freak, it, and particularly Blakely and Booker, were provoked by a series of institutional failures by Congress, the Sentencing Commission, and the executive branch. Some probably inevitable, but some which were probably avoidable. Before describing the institutional failures that in due course provoked the court into Apprendi and Blakely and Booker, let me say two kind words for the federal sentencing guidelines. First, I think guidelines of some sort are a good idea in pretty much any system. Pure, unfettered judicial discretion in the wide intervals between the maximum and minimum sentences set by statutory law is and always has been insupportable. Second, in important respects, the guidelines themselves were a marvel, an ultimately failed marvel to be sure, but a marvel nonetheless. They are, in practical effect, a recodification of federal criminal law, a project that had been tried and had failed multiple times before the Sentencing Reform Act. And in their original form, they were relatively much simpler than what we see today, and with the notable exception of drug cases, significantly less severe than is now the case. Had they maintained their relative simplicity and their relatively lower level of punitiveness, I doubt Booker would ever have happened. The problem was that the guidelines were never designed to be static, and they were placed in the continued stewardship of the Sentencing Commission. Making them subject to regular amendment was in principle a good idea because it should have permitted the creation of a healthy feedback loop between judges, the bar, the Justice Department, the Bureau of Prisons, the Commission, with occasional helpful input from the Academy. That feedback loop should, over the years, have produced guidelines amendments that made the system progressively more acceptable to all the stakeholders, and I suppose, one could hope, more just and more effective as time went on. But the Commission suffered from a number of fatal flaws. Perhaps the most basic was the failure to recognize that, unlike healthy administrative rulemaking bodies, the Commission lacked a balanced constituency, that is to say, strong centers of economic or political power on both sides of the normal dividing lines in the agency's work. The Securities and Exchange Commission, for example, regulates in an environment in which both buyers and sellers of securities have strong advocates who wield political and economic power, and therefore the SEC is perhaps at least less likely to systematically favor one over the other. The Sentencing Commission, by contrast, sets rules for punishing criminals, and there is no significant economic or political lobby for criminals. On the other side, the Justice Department wields great political influence and speaks for the White House, and it reliably and pretty much regardless of administration tends to press for greater punishment. In Congress, political advantage rarely lies in advocating leniency, and critically, unlike in states that have to balance their budgets and in which corrections is a large budget item, for Congress, the cost of incarcerating federal prisoners is a budgetary rounding error. And therefore, the fiscal restraints that often limit states in their urges to punitiveness just don't operate at the federal level, certainly not very reliably. And the commission, though theoretically an independent agency in the judicial branch, has never had any of the real independence that actual Article 3 judges have. There was perhaps a moment when the commission might have asserted itself and with some help from the White House have gained some independence, at least by reputation. Back in 1995, the commission confronted the infamous 100-to-1 crack to powder cocaine weight ratio and passed an amendment reducing that ratio to 1-to-1, from 100-to-1 to 1-to-1. It was an entirely rational choice, entirely supported by the data, and it was a laudable choice. But the Clinton administration, though candidly many inside of it privately agreed on the merits of that change, was determined not to be outflanked on the right on criminal justice issues. So it sent the Justice Department to the Hill to demagogue the issue, with the predictable result that Congress slapped down the commission and rejected the amendment. Pretty much from that day forth, and I don't want to overgeneralize too much, but I think it's fairly true, from that day forth, the commission never again really asserted itself. It always quailed at the prospect of congressional rebuke when it was considering any serious ameliorative amendments. And though it occasionally nibbled at the edges of the guidelines' essentially punitive character, mostly either due to its own internal decisions or due to pressure or advocacy from the outside, it nudged them pretty much ever upwards year by year. And the result from 1987 onward has been that pressure from the department, from Congress, occasionally even from judges, has turned the guidelines, to use the now common metaphor, into a one-way upward ratchet. And for their part, in the pre-Booker era, the judges tried to deal with the guidelines' perceived unduly punitive effects, at least in some individual cases, by making use of the departure mechanism, which was, after all, written right into the guidelines in their first iteration. The Supreme Court tried to help them along, the lower courts along, with its Kuhn decision in 1996, which essentially expanded somewhat the scope of judicial departure power. It was, to be honest, a pretty modest effort at asserting some level of judicial sentencing discretion. But I think it may have assuaged, at the time at least, some judicial concern about the guidelines. Nonetheless, back at the commission, the process of ratcheting their severity upwards continued. Now recall that Apprendi was decided in the year 2000 because of its peculiar facts. It invalidated a law that allowed a sentence above what we would ordinarily think of as a statutory maximum sentence, and did so purely based on a post-verdict judicial finding of fact. Because of those peculiar facts, Apprendi might have been an historical footnote, but it included language that just hinted, that its rule could extend to guideline systems, which caused guideline supporters to quaver a little bit, but not to worry too much. I think that had Congress and the Bush Justice Department been more cautious and been more respectful of judicial sensibilities, nothing more might have come of it. But the Bush Justice Department tightened control over plea bargaining. It encouraged appeals by the Justice Department of downward departures. And likewise, Congress, then in control of Republicans and in a particularly punitive mood, passed in 2003 the Feeney Amendment to the PROTECT Act, which effectively reversed the Kuhn decision, eliminating a number of grounds for departures and imposing a de novo standard of review on appeals for downward departures. And in combination, the actions of the executive and Congress were a direct challenge, perhaps even an insult to the institutional values and the esprit of the federal bench. So the period following the 2000 Apprendi decision was one of ever-increasing federal guideline sentences, and a period in which the judiciary felt increasingly disrespected by the other branches in the criminal realm, and too often forced to impose sentences which, at least in some cases, they could not in good conscience agree to. It's no coincidence, in my view, that Blakely, in which the justices transformed the hint that was offered in Apprendi into a bright line rule that the federal guidelines were plainly going to be on the wrong side of. It's no coincidence, in my view, that that Blakely was decided in the year 2004, only a year after Congress's provocative Feeney Amendment. Within another year, indeed less than a year, the guidelines in Booker were dead, briefly, and then instantaneously resurrected in their current, somewhat anomalous advisory form. In short, what Apprendi became had nothing whatever to do with juries of the Sixth Amendment, and everything to do with both the emotional and pragmatic aspects of relations between the constitutional branches. The second point I want to make here is that the result, at least in federal courts after Booker, is the emergence of what I think is a unique animal, a complex, highly fact-intensive set of, I don't know, what should I call them? Rules, standards, suggestions that look like law, but aren't, at least in any conventional sense. Law, at least as I understand it, is primarily an exercise in which a lawmaker creates rules and a tribunal applies the rules. The mode of law creation can vary: royal prerogative, legislative enactment, administrative regulation, common law judicial action. The type of tribunal can vary: judges, juries, administrative boards, what you will. But the rules will be, at their base, correlations between facts found by a tribunal and a set of identified consequences. The correlation between the facts found and the prescribed consequences can be mandatory or permissive or merely presumptive. For example, a mandatory correlation is one in which if fact A is found, consequence B must be imposed. A permissive correlation is one in which if fact A is found, consequence B may be imposed. A presumptive correlation is one in which if fact A is found, it is presumed that consequence B will be imposed unless the presumption is overcome by proof of some other fact. But there has to be a correlation that, at least at the margins, is enforceable by somebody. In the current post-Apprendi Booker federal world, although trial judges are obliged to perform the law-like rituals of finding facts and matching facts to pre-existing categories of consequence, they're not thereafter compelled to pay any particular attention to the results of their efforts. No consequence is required or permitted or presumed upon the finding of any purely guidelines fact. Now, it behooves us to think about what this thing the judges are doing is. What should it be called? How does it fit with our prior conceptions of law? How can it be meaningfully studied? Does it deserve to be perpetuated? Which brings me to the third point in this brief summary, which is that my personal view is that the existing federal guideline structure should be abandoned at the earliest possible moment. It is simultaneously a colossal waste of judicial and attorney time and a vehicle for propping up at least approximate levels of punishment severity that cannot be fairly justified, except on the circular rationale that these are the levels that have been ground out by the Sentencing Commission and its interactions with Congress over a 3-decade span. Because even though the post-Apprendi Booker guidelines are not law in the proper sense, judges are, by training and instinct, men and women of the law who persist in treating the guidelines like law, which is to say, they persist in treating them like rules correlating facts with outcomes, even though under Booker, they don't have to. And therefore, because they treat this thing, this process, this post-Booker non-law law, because they treat it as law or something like it. The average punishment levels set by the guidelines persist, eroding for some offense types over time, but persisting nonetheless. Now, inasmuch as most observers would agree that those average levels tend to be either objectively too high or at least unjustified by any factor other than habit and administrative fiat, it makes no sense to leave this crumbling superstructure in place, trusting that unpredictable individual judicial deviations from the rules that aren't really rules will somehow rationalize or humanize the whole. I should also add that what I might call the quality of guidelines adjudication is also steadily degrading. I write with my good friend Roger Haynes a treatise on the guidelines that requires us to read all of the reported appellate guidelines decisions every year. The appellate courts have plainly concluded that careful analysis of guidelines questions is basically a waste of time, since trial judges really need not adhere to the rules, beyond going through the motions of finding facts and performing some sort of guidelines calculus. The number of appeals of guidelines issues stayed roughly static, though it slips somewhat year to year. But the rigor of the analysis has fallen off a cliff. A body of semi-law-like advisory somethings that not even judges can be induced to take entirely seriously is frankly not worth keeping. The best thing, of course, from my perspective, would be for the Supreme Court to reconsider the Apprendi line and address the real source of its concern, the appropriate level of constraint that a legislature may place on judicial sentencing discretion in the intervals between true statutory minimum and maximum sentences. If that were done, and if we're done properly, and it can be, there would be constitutional space to create sensible new sentencing schemes for both state and federal courts. That said, I have no expectation that the court will do this. They frankly abandoned consideration of their Apprendi project years ago, probably for two reasons. First, the pure pragmatists probably believed that the objective of defanging the federal guidelines and returning functional control over individual sentencing choices to federal trial judges had largely been accomplished. And second, those who are maybe inclined to think a little deeper realized that the Apprendi, Blakely, Booker line of cases are a logical mess. And untangling it and putting something more sensible in place would involve a long, tedious project of reimagining the whole area of law. And I don't think that the court, either then or now, has either the stomach or the energy for it. Accordingly, the only likely solution to the current federal sentencing mess lies with some combination of the Commission and Congress working to reinvent the guidelines within the strictures of Apprendi-Booker world. That is architecturally possible, although there are meaningful constraints. But the current state of American politics generally makes it unlikely to the last degree. Therefore, I expect to continue co-authoring my sentencing guidelines treatise for many years to come. And should I live so long, to recycle these remarks at a symposium on the 30th and 40th anniversaries of Apprendi. And so with that, I'll close and thank you all once again.